Hello, and welcome back to another deep dive. It is great to have you here with us.
It's great to be back.
We are so excited for this one because we are trying something a little different today.
Yeah, a bit of a change of pace for us.
Usually we take these huge, complicated topics like, space travel or economics, and we try to make sense of them.
That is right.
Yeah.
But today, we are doing something a little special. We are looking at the law.
The law.
Now, usually the law is just full of these big, scary words. Lawyers love to use words that nobody else understands.
Oh, absolutely. It feels like they do it on purpose just to confuse us. But today, our mission is different.
It is.
We have this stack of research articles and legal text about a specific rule.
Yeah.
But we are going to explain it using very, very, very simple English.
That is the challenge. I mean, imagine you are learning English for the first time. Or it's like, imagine you are 5 years old.
Okay.
We are going to break these big ideas down into tiny, tiny pieces so that anyone, and I mean anyone, can understand them.
I love that. No dictionaries needed today, just plain talk. So let's jump in. We are talking about the courtroom.
The courtroom, yeah.
When I think of the courtroom, I think of the movies. I see the lawyer shouting. I see the bad guy crying. And I see the jury, those 12 people sitting in the box watching everything.
We all have that picture in our heads, right? We think the trial is the main event. We think the jury sees everything that happened.
And our research today says that is, well, that's wrong. It says there is a hidden game.
It is a hidden game, absolutely. Think of it this way. Imagine you go to a really nice restaurant.
Okay, I like this.
You're the customer. You sit at the table, you put a napkin on your lap, and you wait for your dinner.
Okay, I am hungry. I am ready to eat.
In this story, the jury is the customer. They're waiting to be fed the facts of the case. They're waiting for the story.
Okay. So the lawyers are the cooks.
Exactly. The lawyers are in the kitchen. They're chopping vegetables. They're cooking the meat, trying to make a meal.
Right.
But there is a boss in the kitchen.
The head chef.
The head chef. And in a courtroom, that head chef is the judge. Now, imagine one of the cooks tries to put a rotten tomato on the plate.
Yuck. No. Don't want that.
The customer, the jury, is sitting out in the dining room. They don't know about the rotten tomato. They were just waiting for their food. But the head chef sees it. The head chef looks at that rotten tomato and says, "Stop. That is bad. Throw it in the trash."
So the customer never sees the rotten tomato.
Never. They never see it, they never smell it, and they definitely don't taste it. The head chef saved them from eating garbage.
I like this analogy. So in a real trial, the rotten tomato is bad evidence.
Yes. Evidence is the stuff the lawyers use to prove their case.
It's stuff.
Yeah, the stuff. Could be a gun, a letter, a photo, or just a person telling a story, a witness. But sometimes that stuff is rotten. It is against the rules.
And the judge, the head chef, has to check the ingredients before the jury gets to eat.
And that checking process, that is what we're talking about today.
That's the hidden game.
That is the topic. It has a really boring name.
Oh.
Federal Rule of Evidence 104. But we can just call it the kitchen rules.
The kitchen rules. I like that. And specifically, the rule talks about preliminary questions. That is a big word. Preliminary.
It is a big word, but it has a simple meaning. Preliminary just means first or before.
So these are the questions the judge has to answer before the real trial even starts.
Exactly. Before the jury comes in, or before the jury sees the evidence, the judge has to ask, is this safe to eat? Is this safe to show the jury?
Okay, I am hooked. I want to know how the chef decides what is rotten and what is fresh. Let's do it.
Let's break it down. There are 5 parts to this rule. We call them sections. We're going to walk through them one by one.
Okay, let's start with section 1. This is Rule 104A. I'm going to call this "The Judge is the Boss."
That is a perfect title. It
Yeah.
really is. The rule says the court must decide any preliminary question.
And the court just means the judge.
Right. Yeah. Just the judge. Now, in this section, the judge is like a gatekeeper.
Huh.
Or let's use a different picture. Think of a nightclub.
Ooh, a nightclub. Okay, I'm with you.
There's a bouncer at the door, big guy, arms crossed. The bouncer decides who gets in and who stays out.
Okay.
The jury is inside the club, dancing and having a good time. The evidence, the witnesses, the papers are the people trying to get in.
And the judge is the bouncer.
Yes. And under this first rule, Rule 104A, the bouncer decides 3 very specific things.
Okay, what are they?
First, witness qualifications.
Qualification just means, is the person good enough to do the job? Like, are they qualified?
Exactly. Let's create a story. We need a story to make this stick. Let's say there's a man named Bob.
Bob. Is Bob a good guy or a bad guy?
Bob is on trial for robbing a bank.
Okay, Bob the bank robber. Got it.
Now, Bob's lawyer wants to bring in a man to help Bob. The lawyer says, this man is a scientist, a brilliant scientist. He will prove that Bob was not at the bank.
That sounds good for Bob.
But the prosecutor, the lawyer against Bob, says, wait a minute, hang on. That man is not a scientist. He is just a guy who reads comic books in his basement.
Oh, so we have a fight. Is he a scientist or is he a comic book fan?
And who decides? The jury is inside the club dancing. They don't know this man exists yet.
The bouncer decides. The judge.
Correct. The judge stops the scientist at the door. The judge asks, show me your diploma. Show me your license. Where did you go to college?
And if the guy says, no, I just watched a YouTube video about science.
Then the judge says, you are not qualified, go home.
Hmm.
And the jury never, ever sees him.
That makes sense. We don't want fake scientists confusing the jury. What is the second thing the judge decides?
The second thing is privilege.
Privilege. That sounds fancy, like having a lot of money or something.
It does, but in the law, it means secrets. Special secrets that you do not have to tell.
Like what? What kind of secrets?
The biggest one is between a husband and a wife. In America, if a husband tells a secret to his wife, the law says the wife usually does not have to tell the police. It is a privileged secret.
Okay, so let's go back to Bob. Imagine Bob went home and told his wife, honey, I robbed the bank.
And the prosecutor wants to force the wife to get up there and tell the jury what he said.
But she says, no, that is a private marriage secret. You can't make me.
Again, who decides?
Judge.
The judge. The judge listens to the argument and decides if the secret is Dave's or if she has to talk.
Okay, so witness qualifications, secrets, and the third thing.
The third thing is the big one. Admissibility.
Admissibility. That is a mouthful.
It comes from the word admit, like admitting someone into the club. It just means, is this evidence allowed by the rules? Is this piece of stuff okay to bring in?
So, like, is the photo real? Was the letter stolen? Is the gun the right gun? All those questions.
Exactly. All of them. If it breaks the rules, the judge says, not admissible. It stays outside the club.
So the judge has all the power. But here is where it gets really weird. I was reading the notes on this rule, and I found something that sounds, it sounds impossible.
Ah. You found the no rules rule.
Yes. The text says, in so deciding, the court is not bound by evidence rules except those on privilege.
This is a brain twister for sure.
Let me see if I can say it simply. The judge uses the rule book to decide if the evidence is good, but the judge does not have to follow the rule book to make that decision.
That is exactly right.
Sounds like cheating, doesn't it?
It sounds totally like cheating. How can you enforce the rules if you yourself are breaking them?
Okay, let's go back to the kitchen. The head chef.
Okay.
The rule is, do not serve the customer rotten food.
Right. Simple rule.
How does the chef know if the milk is rotten?
He has to smell it.
Mwah.
Or maybe taste a tiny, tiny drop.
Exactly. He has to taste the bad milk to know it is bad. If there was a rule that said the chef can never taste bad milk, he could never do his job. He wouldn't know what to throw away. Oh, I see. So to check the evidence, the judge has to look at the evidence, even if the evidence is illegal or, rotten.
Yes. Let's look at Bob the bank robber again. Remember the fake scientist?
The comic book guy? Yeah.
Imagine he brings a letter from a college that says he is a real doctor.
Okay.
But the letter looks fake. It is written in crayon.
Classic Bob. Or Bob's friend.
Now, usually, a letter written in crayon is hearsay. Hearsay is the kind of evidence that the jury is not allowed to see. It is usually against the rules.
Okay, so a crayon letter is a no-go for the jury.
A total no-go. But the judge needs to know if the man is a doctor. So the judge puts on special glasses. Let's call them legal X-ray specs.
I like that. Magic glasses.
With these glasses, the judge is allowed to read the crayon letter. The judge breaks the rule against hearsay, just for a minute, to check the facts.
But the judge reads it and says, this is written in crayon, this is fake, obviously.
Right. Then the judge takes off the magic glasses and says, okay, throw the letter in the trash. The jury can never see it.
So the judge is allowed to look at the forbidden stuff so that he can protect the jury from it.
Precisely. The only thing the judge cannot look at is the marriage secrets. The privilege.
The privilege.
Right. Even the judge cannot listen to the secret Bob told his wife. That is the one line the judge cannot cross. But everything else, hearsay, rumors, stolen letters, the judge can look at all of it to make his decision.
But why do we trust the judge so much? Why don't we let the jury see the crayon letter and decide for themselves if it's fake?
That is a great question. And the advisory committee, the people who wrote these rules, They had an answer for that. They said the rules are there to protect the jury
Protect them from what?
from confusion. The jury's made of normal people, plumbers, teachers, bus drivers. They don't know the law. If they see a letter, they might believe it. Even if it is fake, they might get tricked.
But the judge.
The judge is a pro. The judge is an expert. The law assumes the judge has a legal mind. The judge can look at the messy information, separate the good from the bad, and not get confused by it all.
So the judge is like a parent. The parent can touch the hot stove to see if it is hot, but the jury must stay away.
That is a perfect way to put it.
Okay, I think I get section 1. The judge is the boss. He can look at anything to check the ingredients. Now, let's move to section 2. This is Rule 104B.
This section is different. This is where the judge steps back a little bit, takes a smaller role.
The title is complicated. Relevance. That depends on a fact. That's a mouthful.
It is. Let's simplify that. Let's call it the missing link, or the puzzle piece.
I love puzzles. Tell me how this works.
Okay. Imagine the police find a note in the trash can outside the bank.
Okay.
The note says, "I am going to rob the bank at noon."
Ooh. That is a smoking gun. That is huge evidence.
Well,
Yeah. It says they are going to rob the bank.
but who wrote it?
I assume Bob wrote it. He's on trial.
But what if I wrote it?
Hmm.
Or what if a random teenager wrote it as a joke and threw it away?
Oh, okay. If a random teenager wrote it, then it has nothing to do with Bob. It's just trash.
Exactly. If a stranger wrote it, the note is meaningless. It is only relevant. It only matters if Bob wrote it.
So the fact we need is Bob wrote this note.
Yes, that is the missing link. The note is like a blue puzzle piece. You don't know if it fits in the sky or the ocean until you find the piece next to it.
So here's my question. Who decides if Bob wrote the note? Does the judge decide, like he did with the scientist?
This is the tricky part. In Section 1, we said the judge decides everything. He's the boss. But here, the rule changes.
Why? Why the change?
Because deciding, did Bob write the note, is basically the same as deciding, did Bob commit the crime.
Oh, I see. If the judge says, yes, Bob wrote it, the judge is kind of saying Bob is guilty.
Right. And we do not want the judge to decide if Bob is guilty. That is the jury's job. We want the jury to solve the puzzle.
So what does the judge do? Just let anything in?
No. The judge plays a smaller role. The judge just checks for possibility.
Possibility.
The judge looks at the note and asks, is there enough proof here that a jury could believe Bob wrote it? Maybe there's a fingerprint that might be Bob's, or a witness who saw someone who looked like Bob near the trash can.
So he doesn't have to be 100% sure.
Not at all. He just checks if it is reasonable. If it is possible that Bob wrote it, the judge says, okay, let the jury see it, let them decide.
I see the difference. In Section 1, the judge checks if the evidence is legal. In Section 2, the jury decides if the evidence is true.
You got it. The judge opens the gate, but he lets the jury decide if the visitor is actually Bob.
Now, there is one more fun thing in this section. I was reading about it. It is called the later promise.
Ah, yes. This happens when trials get messy and out of order.
Ideally, the lawyer would say, Step 1, here is a witness who saw Bob write the note. Step 2, now here's the note.
Right, connect the dots in order. 1, then 2, it's clean.
But sometimes the witness is late, his car broke down, he isn't at the court yet.
And the lawyer's standing there holding the note. He wants to show the note now, but he can't prove Bob wrote it yet. He's stuck.
Can the judge let him show it?
Yes. The rule says the judge can admit the evidence subject to connection later.
It is a promise, like an IOU.
Exactly.
Yeah.
The lawyer says, Judge, please trust me. Let me show the note now. I promise my witness is coming tomorrow to prove Bob wrote it.
And the judge can say, okay, I trust you. Go ahead.
But what happens if the witness never comes? What if the lawyer was mistaken or just lied?
Or what if the witness comes tomorrow and says, I never saw Bob write that note in my life?
Then the chain is broken. The puzzle piece doesn't fit after all.
So what does the judge do? The jury already saw the note.
The judge has to tell the jury to strike it. He turns to them and says, hey, remember that note from yesterday? Forget it. Pretend you never saw it.
Wow. That goes back to the human brain problem. Can the jury really forget the note? Can they just erase it?
It is very, very hard. It is like telling someone, do not think of a pink elephant.
I am thinking of a pink elephant right now. It has a little hat on.
Exactly. And that leads us perfectly into Section 3.
Yeah.
Because sometimes asking the jury to forget is just too dangerous. You can't risk it.
Section 3. This is Rule 104C. I call this secrets from the jury.
This section is all about protecting the jury's brain. It lists times when the jury must leave the room.
Like, get out, go stand in the hallway. We don't want you here for this.
Yes, go have a coffee. We need to talk about something you absolutely cannot hear.
The biggest example here, according to the research, is a confession.
A confession is when the bad guy says, I did it. It's the most powerful kind of evidence.
Let's go back to Bob. Imagine the police catch Bob, they bring him to the station, and Bob signs a piece of paper that says, I robbed the bank.
That is the end of the case, right? He confessed. It's over.
But wait, Bob says no. The police beat me up. They hit me for hours until I signed it. They wouldn't let me sleep.
Whoa, that is serious. In America, if the police hurt you or force you to get a confession, that confession is illegal. We cannot use it.
It is a rotten tomato, a really, really rotten one.
Exactly. Now remember our restaurant. If the chef wants to check if the tomato is rotten, does he bring it out to the table and show the customer first?
No, of course not. If the customer sees the rotten tomato, they might lose their appetite. Even if you take it away, they will remember it.
Exactly. Same with the confession. Imagine if the lawyers argued about this in front of the jury. The prosecutor says, Bob confessed. Bob says, they beat me.
The jury hears Bob confessed, and that's all they hear.
And even if the judge later says, okay, the confession is illegal, throw it away, the damage is done, the jury sits there thinking, well, legally we can't use it,
Yeah.
but I know he said he did it, so he must be guilty.
You cannot unhear a confession. It is just too powerful. It sticks in your brain.
Right. So Rule 104C says, when there's an argument about a confession, the jury must leave the room. No exceptions.
Secret meeting.
Yes. The jury leaves, the door is locked.
Yeah.
Then the lawyers and the judge argue. They might even have witnesses, like the police officer, come in and talk. The judge decides if the confession was voluntary or forced.
And if the judge decides it was forced?
He throws it out, the jury comes back in, and they never know a concession even existed. Bob is safe.
That seems really fair. There is a famous case about this, right? It's mentioned in the notes.
Yes, a case called Jackson v. Deno. It went all the way to the Supreme Court. And the court said, basically what we just said, you cannot trust a jury to ignore a confession. It is just human nature. If they hear it, they will use it. So they cannot hear it unless the judge says it is okay first.
Okay, so confessions are a definite jury out. Are there other times the jury has to leave?
Yes. Case number 2, when the defendant asks.
So if Bob is going to talk to the judge about a legal rule, Bob can ask the jury to leave.
Yes. If Bob himself is a witness for this specific preliminary question and he requests it, the judge must say yes.
Why is that?
It helps Bob feel safe. Imagine Bob wants to explain something complicated to the judge. He might be nervous if the jury is staring at him. He might look sweaty or guilty, even if he's not. So he can ask for privacy to make his case to the judge.
And is there a third case? A final one?
There is always a catch-all, a safety net. The rule says the jury must leave if justice so requires.
That just means if it would be unfair for them to stay, kick them out.
Exactly. If it smells like a rotten tomato, get the customer out of the room.
Yeah.
But sometimes they can stay.
Really? When?
If the argument is boring, they can stay.
Boring. Like what?
Imagine the lawyers are arguing about a map. Is this map from 2020 or 2021? Or is this a proper copy of the document?
That is not a dangerous secret. That's not going to change my mind about whether Bob is guilty.
Right. If the jury hears that, it won't ruin the case. So to save time, the judge might say, just stay in your seats. We will figure this out quickly.
Okay, so Section 3 is hide the dangerous stuff. Don't let the jury hear things that will poison their minds. Now, let's move to Section 4. This is my favorite part, I think. Rule 104D. I call this the safe zone.
Or the shield. This is a rule that protects the defendant. It's a really important one.
Let's go back to Bob again.
Poor Bob. He's having a rough day.
Bob has another problem. The police found the map of the bank in his house, the one he used to plan the robbery.
Okay, that's not good for Bob.
The police broke into his house without a warrant. They just kicked down his door illegally.
That is a big no-no in the law, a huge one. If the police break the law to find evidence, they cannot use the evidence. It's called the exclusionary rule.
So Bob wants to tell the judge, hey, they broke my door. You can't use that map.
Okay, so Bob needs to get on the witness stand and tell his story about the broken door.
But Bob is scared. He's terrified.
Why is he scared? He's telling the truth about the door.
Because the prosecutor is sitting there,
Yeah.
and the prosecutor looks like a shark.
Okay.
Usually when you get on the witness stand, you are opening the door. It means the other lawyer can ask you anything.
This is cross-examination.
Right. So Bob is thinking, if I get on the stand to talk about my broken door, Will the prosecutor then get to ask me if I robbed the bank?
That is the trap.
No.
The prosecutor could say, oh, while you were here, Bob, did you steal the money? Did you use this map to do it?
And Bob would have to answer, or plead the fifth, which makes him look guilty.
So Bob is trapped. If he complains about the door, he might have to confess to the crime. If he stays silent, they use the illegally obtained map against him. It's a terrible choice.
This is where Rule 104 saves the day. It creates a shield.
A force field, yeah.
The rule says, by testifying on a preliminary question, a defendant does not become subject to cross-examination on other issues.
Can you translate that into simple English for us?
It means Bob can enter the safe zone. He can go to the witness stand and say, I am only here to talk about the broken door. Nothing else.
And if the prosecutor tries to ask about the bank robbery?
The judge jumps in and says, stop. You cannot ask that. Stay on the topic of the door.
Nice. So Bob can fix the legal problem, the door, without risking the main case, the robbery.
Exactly. It encourages people to fight for their rights. We want people to speak up when the police break the rules. If Bob was too scared to speak, the police would get away with it.
Is there a catch? It sounds too good to be true.
There is always a catch.
I knew it.
The shield only works if Bob stays on topic, if he stays in the safe zone.
What do you mean?
Imagine Bob gets on the stand. He says, the police broke my door to get the map. That is fine.
Safe zone is active. Shield is up.
But then Bob keeps talking. He gets emotional. He says, and they shouldn't have broken in because I wasn't even home. I was at the movies seeing a film. And besides, I never robbed banks.
Oops. Bob talked too much.
He dropped the shield. He started talking about the robbery and his alibi. He left the safe zone.
So now the prosecutor can attack.
Yes. Now the prosecutor can say, oh, you were at the movies. Which movie? What time? Do you have a ticket stub? Who are you with? The door is now wide open.
Bob opened the door himself.
Exactly. So the lesson for Bob is, keep it simple. Answer the question about the door and then shut up.
Zim it. Don't say another word.
Don't volunteer extra information. Stick to the script.
Okay, so Section 4 is the shield. It lets you fix the kitchen rules without getting grilled about the main meal.
That is a great way to say it.
We are almost there. We have one section left, Section 5, Rule 104E. I call this the final battle.
This section is about two big words, admissibility and weight.
We know admissibility. We've talked about it a lot. That is, can the jury see it? The judge decides that.
Yes. The judge opens the gate.
What is weight?
Weight means,
Yeah.
how heavy is it? But in the law, it means how much should we believe this? Or how important is this piece of evidence?
And who decides the weight?
The jury.
Okay, let's play this out with Bob. Let's go back to the confession.
Okay, the secret meeting happens. The jury is out of the room. The judge listens to the
The
arguments.
judge decides. The police did not beat Bob up. The confession is legal. It's a fresh tomato.
So the judge opens the gate. He admits the confession.
Now the jury sees the paper where Bob wrote, I did it.
Does Bob have to give up? Does Bob's lawyer have to say, well, the judge let it in, so I guess we lose?
No.
Absolutely not. Rule 104E says the fight is not over. Just because the evidence is in the courtroom doesn't mean it wins the game.
So what can Bob's lawyer do now?
He can turn to the jury and say, ladies and gentlemen, look at this confession. Sure, Bob signed it. The judge said you could see it, but look at Bob.
He had been awake for 40 hours. He was starving. He was terrified. The police officer was screaming at him. He would have signed a paper saying he was a Martian just to get a sandwich and a nap.
Exactly. The lawyer is attacking the weight of the evidence. He is saying, this evidence is garbage. It is weak. It might be legally okay, but it's not true. You should give it 0 weight.
And the judge allows this, even after he said the confession was okay.
Yes. The judge says, my job was just to check if it was legal, if it followed the pitch-in rules. Your job, jury, is to decide if it is true. You decide how much you believe it.
This is a really important distinction. The judge is the gatekeeper, but the jury is the, what? The truth finder.
The truth finder. That's perfect. Just because a witness is allowed to talk doesn't mean the jury has to believe him. If a witness is sweating and looking at his feet and changing his story...
The jury can throw his words in the mental trash can.
Yeah.
They can give his testimony 0 weight.
Exactly. Rule 104E protects the jury's power. It says the jury has the final say on who is lying and who is telling the truth.
This is amazing. When you put it all together, it really is a system, a whole hidden world.
It is a game with very strict rules.
Let's do a quick recap of the game for our listeners just to put it all together.
Yeah.
Step 1, the kitchen check. Rule 104A. The judge is the boss. He breaks the rules, except for secrets, to check the ingredients. He keeps the rotten tomatoes away from the jury.
Right.
Step 2, the puzzle piece. Rule 104B. If evidence depends on a missing link, like who wrote the note, the judge just checks if it's possible and lets the jury decide if it's actually true.
And the lawyer can promise to connect the dots later.
Step 3, the secret meeting. Rule 104C. Sometimes the jury must leave the room, especially for confessions, because you cannot unhear a confession.
Protect the brain from prejudice.
Step 4, the shield. Rule 104. Bob can talk about his broken door without being attacked about the bank robbery, as long as he stays on topic.
The safe zone.
And step 5, the final battle. Rule 104E. Even if the evidence gets in, you can still tell the jury it is trash, and they shouldn't believe it.
Admissibility versus weight.
This has been fascinating. I feel like I understand what is happening on TV now.
It changes how you watch a trial, doesn't it? You realize the most important fights happen when the jury's not even in the room.
But I have one final thought, a provocative thought for everyone listening.
Okay, give it to me.
We talked a lot about the judge. The judge puts on the x-ray specs, the judge reads the fake letter, the judge hears the illegal confession that was beaten out of Bob.
Yes, all in secret.
Then the judge says, throw it out, and he tries to be fair.
That is the job. That's what we trust them to do.
But the judge is a human being. He has a human brain, just like a juror. Can a human brain really unsee that stuff?
That is the big question.
If the judge reads a letter that says Bob is guilty and then throws it out for legal reasons, won't he still deep down think Bob is guilty? Can he really be a neutral referee after seeing the rotten tomato himself?
We put a huge amount of trust in judges. We expect them to be like robots who can just delete a file from their hard drive. But you are right. They are human. And maybe they can't forget the taste of the rotten tomato.
It is scary to think about. But I guess it is the best system we have.
It is. It is not perfect, but it tries very, very hard to be fair.
Right, on that note, we are going to wrap up. Thank you so much for listening to this deep dive on Federal Rule of Evidence 104. We hope you feel a little bit smarter today.
And remember, if you ever find a smoking gun, make sure you know who it belongs to.
See you next time.